Basic Appraisal Principles, page 286, Unit 3, Legal Considerations. To claim ignorance of a recorded document. Even if they didn't actually see the document, if it was in the public record, they had the opportunity to see it. So they are deemed to have had constructive notice of it. For example, Swift grants an easement across his property to Jefferson, and Jefferson records the easement. Swift then sells his property to White. White later claims that Jefferson's easement is extinguished because she couldn't tell that it existed by looking at the property had Swift never told her about it. But the easement is still valid. Although White did not have actual notice of the easement when she bought the property, she is deemed to have had constructive notice of it. If she had checked the public record, she would have found the recorded easement. The race/notice rule. Recording systems are created and governed by state laws, and they vary from one state to another. Some states have a recording system known as a race/notice rule. In effect, when there are competing interests in a property, there is a race to record. Whoever records a deed first wins the race, as long as the winner did not have notice of any previous conveyances. For example, Connolly sells property to O'Donnell and gives him a deed on June 10th. O'Donnell fails to record his deed. Then, on August 15th, Connolly sells the same property to McMurphy. McMurphy has no knowledge of the sale to O'Donnell. McMurphy records her deed on August 15th, the same day she received it. McMurphy would win a lawsuit to determine ownership of the property, even though O'Donnell actually purchased the property first. McMurphy won the race by recording her deed first, and she had no notice of the previous sale. A subsequent purchaser who has notice of a previous conveyance can never have good title, even if his or her deed is recorded first. In the example above, if McMurphy had been aware of the prior conveyance to O'Donnell, or if O'Donnell had taken possession of the property, McMurphy would not have good title, even though she recorded her deed before O'Donnell recorded his. The recording process. Each state will have its own process for recording legal documents. The following is an example of how this public recording system might work. See Figure 11.1. For example, each county may have its own public recorder's office, known as the County Recorder's Office or the Registrar of Titles Office. The person in charge is called the recorder or registrar. To have a document affecting title to real property recorded. The original or a certified copy of the document is filed at the public recorder's office in the county where the property is located. Documents pertaining to certain federal land may be recorded at the Bureau of Land Management. The date and time a document is received at the recorder's office is noted because time of filing can affect the priority of interests in a property. After a document is filed with the recorder, it is copied and placed in the public record. Recorded documents are generally numbered in chronological order, according to the time and date of filing. These recording numbers can later be used to locate a particular document in the public record. After recording a document, the recorder's office returns the original to the person who filed it for recording, or to someone else specified by that person. Page 287. Figure 11.1. The recording process. You start at the top with the original or certified document. That goes to the recorder's office. Then to the document stamped with date and time, priority of interests. Then that goes to gets copies made for recorder's office file. Then it goes back, the original document returned to the owner. Reception books. Some states maintain reception books where the public recorder keeps two books, the grantor's and grantee's reception books, to log in documents that are filed for record. Each jurisdiction may have a slightly different layout in its reception books and are intended to show for each recorded document such things as: number 1, the date of reception, year, day, hour, and minute. Number 2, the grantor's name. Number 3, the grantee's name. Number 4, where the property is situated. Number 5, to whom the document is to be delivered after recording. Number 6, the fees paid. And 7, the book and page where the document is recorded and the type of instrument it is. For instance, deed, mortgage, lien, etc. The reception books generally list each document in the order it is received. They are used to account for each document number and to help people find documents that have been accepted for recording but have not yet been indexed. Indexes. The recorder indexes deeds and other documents in alphabetical order by the last name of the grantor and by the last name of the grantee. In some states, deeds are also indexed according to tract. A tract index groups all recorded documents pertaining to a particular property. For instance, a particular tract. Tract indexes might be maintained by the governing jurisdiction, but generally they are not considered official.